I'm Eli Salzberger. I'm the director of the Minerva Center for the Study of the Rule of Law Under Extreme Conditions. This Minerva Center was established 10 years ago by the Minerva Foundation, which is an offspring of the Max Planck Society. Our mission is to focus on the rule of law under extreme conditions, how natural disasters, man-made disasters, wars, belligerencies, extreme socio-economic crises affect the rule of law, should affect the rule of law. But we hold this event tonight because we believe that the rule of law in Israel is currently under extreme conditions, independently from any external circumstances or disasters. As you may know, following the results of the general election held 7 weeks ago, a new government is about to be formed, which will be the most right-wing religious government Israel have ever seen. From the coalition agreements that have been signed between the Likud and the other parties slated to form the government, it emerges that the new government is planning major reform in the judiciary, in the state public legal apparatus, and in the relationship between the powers, the branches of government. In our opinion, the accumulation of these reforms will amount to a constitutional and regime change. And if materialized, they will pose a significant threat to the rule of law and to the democratic nature of Israel. As you know, Israel is ranked by various democracy ranking as a flawed democracy currently in a proper 20% place. And we believe that if this measures will materialize, Israel will drop to a hybrid regime. What are the planned reforms? One of them is the overruling clause, which will allow the Knesset to overturn decisions of the Supreme Court, particularly constitutional decisions. The parliament will be enabled to legislate laws that the Supreme Court ruled as void and null because of infringement of basic law, human dignity, and liberty. Professor Amnon Reichman will elaborate on this point in a second. Another planned reform is the procedure for judicial appointments. In 1953, the Knesset legislated the Judges' Law, which sets the procedure for appointments of all judges in Israel. This appointment is made by a 9 members committee comprising representatives of the 3 branches of government and the legal profession. This system served as a model for other countries. The UK, for example, changed its appointment system partly inspired by the Israeli system. The new government is planning either to abolish the committee and empower the Knesset to elect judges, Supreme Court and other judges, or to change the composition of the committee in a way that politicians from the coalition will have an automatic majority in it. This initiative is accompanied by lowering the mandatory retirement age of judges, which is currently 70, in order to get rid of the current liberal judges. Sounds familiar? The last initiative is based on similar steps taken in Hungary and Poland. Professor Gadi Barzilai will elaborate after Amnon on judicial appointments and the proposed reforms. The new coalition is also planning to make changes to the public legal service and particularly to the Attorney General office. Currently, the Attorney General is in charge, among other functions, of all legal counselors of the different ministries. The plan is to make these ministerial legal advisor a trust appointment of the minister, with a grim ramification of a surge in corruption. Speaking of corruption, another law being legislated as we speak at the moment will enable Aryeh Deri, the leader of the Sephardic ultra-Orthodox party and twice convicted for corruption, to become the Minister of Finance. It is important in the context of the changes in the judiciary and the Attorney General and the public legal apparatus to emphasize that Israel's structure of government lacks key elements of separation of powers and checks and balances, no separation between the legislature and the executive, only one house of parliament, no vertical separation, federation structure or something like that. So at the moment, the judiciary and the public legal apparatus are in fact the only balancing power to the raw majority. Abolishing their independence will transform Israel, as I said, from a flawed democracy to a hybrid regime. Dr. Maya Mark will elaborate on some of the changes in the public legal services, and we'll talk about the democratic rhetoric to justify all these anti-democratic systems. Reforms, sorry. Another set of reforms, which in fact the Knesset has already begun legislating, even though the new government was not sworn in yet, is a reform in the command chain of the army and the police. Itamar Ben-Gvir, who was convicted 8 times by the courts, among other offenses for incitement to racism and terror, is due to be appointed the Minister for Home Security or National Security, and he conditioned it on changing the command structure of the police. Bezalel Smotrich, the head of the Jewish National Party, is due to become the finance minister, but his party is due to hold a minister at the defense ministry who will be in charge of the civil administration in the occupied territories. Currently, the army is the sovereign power of in the occupied territories as derived from international law. Professor Sandy Kendar will conclude this panel and will discuss some of these reforms and whether they mean annexation de jure of the occupied territories. So after this short presentation, and I have to apologize on behalf of Professor Itamar Man, who is sick and couldn't join us. After this short presentation of Amnon, Gadi, Maya, and Sandy, we will allow also other faculty members and Minerva Center members to add the remarks, and then we'll conduct a question and answer session. I want to emphasize that this event does not attempt to cover all the planned reforms, and we will focus here mainly on the legal constitutional ones. And I want to emphasize also that this is not an in-depth academic conference in which we try to balance between different viewpoints. It is, as we dubbed it, an information and analysis session, which expresses the deep concern of the Minerva team to the democratic future of Israel. So I want to hand the floor to Professor Amnon Reichman from the law faculty of the University of Haifa and the director of the Center for the Rule of Law and a principal investigator at the Minerva Center. Amnon, the floor is yours.
Thank you very much, Eli, and thank you all for taking the time to participate in this event. What I want to do in my 5 minutes, Eli, it is a kind of the time frame, sort of.
7 minutes, Amnon.
7 minutes. Oh, that's an increase of almost 20%. That's great. Since I participated in the Knesset debate on Itamar Ben-Gvir, we were allotted only 3 minutes, so 7 minutes is a lot of time. So I wanted to do two things. First, contextualize the debate in non-legal terminology, and then in the later part, shift to the law and the structural element that the notwithstanding clause, as it is known in the legal jargon, may inflict on the Israeli structural design. So why are we here? And I think that may be relevant for the other components being considered at the moment. Why are we here? We are here in part because in the 90s, it seems as if Israel was on the verge of, I wouldn't say solving, but at least mitigating three of the most significant cleavages in its society, namely the Israeli-Palestinian struggle, the strife between the religious and the non-religious components of the Jewish state, and Israel's market identity in terms of socialism versus market-based economy. Now, the 90s, recall, was the era of the Oslo Accord, and it appeared as if this issue will be solved by establishing the Palestinian state of some sort, and Sandy will address what it means with respect to the territories. But with respect to the court and its ability to exercise judicial review, the court thought, or the court came to the conclusion that its hesitancy to exercise judicial review over the territory is no longer warranted, and it should hold Israel to account with respect to the territories as well. With respect to the religious division, the court took in the 80s and in the 90s some moves to establish the rule of law, not only with respect to the territories, but also to establish the rule of law with respect to the debate or the struggle between the religious and non-religious components of the state of Israel. And finally, with respect to the market, it appeared as if Israel was settling on some sort of market-based, but with some socialist components. Why am I saying that? I'm saying that because in the 90s, the Israeli Knesset adopted two basic laws: Basic Law, Human Dignity and Liberty, and Basic Law, Freedom of Vocation, translated as freedom of occupation, but I won't get into that. And the idea there was the court was asked, even though not specifically, but was asked because of the design of the basic laws, to check whether Knesset legislation that infringes the rights specified under these basic laws does so in a proportionate manner, whether the law infringes the right in a manner that befits the values of the state of Israel as a Jewish democracy, does so for an appropriate purpose, and is proportionate in its infringement of the rights. So the court started to exercise constitutional judicial review, and the court was ready to do that because, politically speaking, it appeared that the major cleavages within Israeli society are towards some sort of resolution. It appears that this was not the case. And now because the court has begun to exercise this kind of constitutional judicial review, and in addition, expanded or solidified or crystallized its doctrine, its reasonableness doctrine, other administrative law doctrine with respect to the exercise of administrative discretion by the authorities, including by the authorities in the West Bank, including by authorities with respect to the ultra-religious component, the draft of ultra-religious yeshiva buchers, yeshiva students to the army and other issues, and its approach towards other structural matters. The court began to exercise judicial review that is more on par with what is the norm in Western liberal democracies, and that resulted in a backlash. The idea was that the court, even though there is a limitation clause in the basic clause, there is a specific, within the basic clause, section that says that all laws should be checked for compliance with their purpose, as I said before, their values, their purpose, and their proportionality indeed befit the state of Israel. Nonetheless, there was a backlash. And now the legislature, and I'm moving now to the legal part, now the legislature is considering to include a notwithstanding clause or an override clause. Now, there is already an override clause in the Basic Law Freedom of Vocation, which was a reaction by the ultra-Orthodox parties. They wanted to exempt laws pertaining to the import of non-kosher meat, and in order to do that, the Basic Law was changed. But this notwithstanding or override clause was never exercised, and the Basic Law of Freedom of Vocation itself was really has really been shrunk by the court, and hasn't been in fact activated in order to invalidate legislation after the notwithstanding clause in any actually meaningful sense. Now the idea is to export this notwithstanding clause and implement it also with respect to Basic Law, Human Dignity and Liberty, which is the main source of human rights in Israel at the constitutional level. And not only to do so, but to do so in a manner that basically places no real hurdles for the coalition government to exercise this override clause. By that we mean that the majority that will be needed in order to exercise the notwithstanding clause will be just 61 out of the 120 members of the Knesset, and any government has 60, by definition, has 61 members of parliament supporting it. Otherwise, it would no longer be able to rule. So it would only need to rely on its basic majority in order to exercise this override clause, and it could exercise it with respect to any rights. Equality and freedom of expression and privacy and property and freedom of vocation as it is now, freedom of movement, freedom of religion, all rights derived of human dignity. I should mention that the Basic Law itself doesn't enumerate most of these rights. The court has interpreted the right of human dignity to include those rights, but nonetheless the override clause could be used with respect to all these rights, with respect to just the majority of 61, and also, as the proposal currently stands, it will also be able to be used to immunize a statute from judicial review a priori. So you won't even need to wait for the court to strike down a certain statute. You could immunize it by passing the law using the notwithstanding clause, with the majority of 61 saying this law is passed notwithstanding the Basic Law, and then the court will be prevented from exercising judicial review a priori, that is, before even the statute is being implemented. Now, I must say that there could be arrangements under which we could live with the notwithstanding clause. The notwithstanding clause could be, if crafted very diligently and carefully, could be a component of a system. For example, it could, if the Knesset legislates all missing rights, and if the Knesset secures the status of the court, the status of the court in Israel under our Basic Laws is not secure because any majority can change the composition of the court, and Gadi Barzilai will address this in a second. So if all remaining rights are legislated or enacted into the Basic Clause, if the role and status of the court is protected, and if the majority of the exercise of such override is higher, let's say 65 or 70, including members of the opposition, substantive opposition, not opposition to the right of or to the left of, opposition that is actually from the other segment of the parliament, and it cannot be exercised prior to the invalidation by a court, and it can only be exercised if a statute is being struck down with a majority of one justice. Okay, you see all these conditions very carefully crafted, then we can live with it. But the idea behind the notwithstanding clause, again, the origin of the notwithstanding clause is in Canada, although Canada borrowed it from earlier debates in the United States in the 20s and 30s. So some configuration of a notwithstanding clause could be a good idea, but the drive between the current proposals is not to craft a delicate structure of a balance of power that allows all segments to be part of a debate and deliberation and discourse as they should, but rather to silence the court, rather to just say, thank you very much, dear judges. We're not interested. We just need to have the power to rule. We need the power to govern. You're in our way, obstructing our ability to exercise whatever power we want to exercise by statute, and we just need the device to remove any judgment or future judgment out of the way. I want to also say that the term overrule clause or notwithstanding clause is colloquially used also to include mechanisms that will allow the government or the Knesset to exercise its power to set aside administrative law judgments by the High Court of Justice. That is, if the court doesn't invalidate the statute, but says that a certain administrative action is ultra vires, sometimes the term notwithstanding clause is used to say we need to empower the government to act notwithstanding the judicial judgment with respect to an agency decision as well, or a governmental decision as well, in order to set aside also administrative judicial review. Luckily, I want to conclude with some notion of optimism, because my time is almost up. Luckily, it is up. I realize it is up. Luckily, the idea of the coalition was to pass the notwithstanding clause as part of the blitz, the legislative blitz we're currently experiencing, which includes statutes that Eli mentioned before with respect to Ben Gvir ruling the police, and with respect to Deri being allowed to circumvent the checking function of the basic law that is designed to say whether there's calamity in his actions and therefore is not authorized to be a minister. But fortunately, this was set aside for the time being. So we will, I guess, proceed with this as soon as the government is enacted. And the timeline is towards April, the Jewish Passover. But if the government decides to go ahead with it, they have the votes. And then it will be up to us, civil society, the academic community, and with input from abroad as well, to voice our deep concerns that this mechanism could be used to undermine the whole idea of judicial review, thereby leading to a demise or a significant decrease in the ability of the court to protect fundamental rights. I will, of course, be happy to answer any questions later.
Yeah, thank you very much, Amnon. So we heard about the plan to enable overruling of every judicial decision. And now we'll hear about the plan to change the judges, the judiciary. Professor Gadi Barzilai, who was the Dean of the Faculty of Law at the University of Haifa and the Vice Provost of the university, and is a principal investigator at the Minerva. The floor is yours.
So thanks everybody for coming. Happy Hanukkah, Merry Christmas, Eid al-Kabir. And as Professor Zalzberg mentioned, I would like to talk very briefly in about 7-8 minutes about the proposal to change the election system to the Israeli Supreme Court, or by and large to the Israeli judiciary. Facing the lack of an overall written constitution, and Israel does not have an entrenched bill of civil rights or human rights, a basic law, freedom of dignity that Professor Reichman mentioned is obviously only a very limited piece of legislation which is supposed to protect civil rights. So taking into account that kind of a backdrop, obviously the Israeli Supreme Court have had a pivotal role. Now, here I would like to make a distinction between judicial policies and structure. So first of all, to those of you who are not following the Israeli Supreme Court, it does have 15 justices, 15 positions, and retirement age is 70. So it's very different for those of you who are coming from the United States. It's very different, obviously, from the American system. Now, talking about judicial policies, you have a very convoluted Supreme Court, traditionally speaking. On the one hand, it has been, after the mid-80s, liberal and progressive regarding gender equality, privatization of Orthodox religion and Orthodox institutions. On the other hand, talking about the 1967 occupied territories, it has been highly conservative, and in many ways, and I guess Professor Kedar will talk about it, it has legitimized the status quo of an occupation or actual annexation. So on the one hand, it has been a liberal court, and on the other hand, it has been a very conservative court. Now, structurally speaking, the Israeli Supreme Court has been considered to be with a very high level of judicial independence. So there is a forthcoming article that I'm drafting and supposed to be published in a few weeks, analyzing data published by the IMF. So based on data of the IMF, Israel is really one of the most prominent countries with judicial independence, alongside countries like Australia and England that Professor Salzberger mentioned before, and in a much better condition than Germany or the United States. Now, until 1953, the Supreme Court has been, all of it was politicized, and all justices till 1953 were selected by political parties. However, until the early 1950s, the Israeli political system has not been even nearly as polarized and fragmented as it is today. Now, after 1953, and especially after 1984, we have a very professional committee, an election judicial committee composed of 9 members. 3 members by law, by the basic law of the judiciary, should be Supreme Court justices, including the Chief Justice, that we call in Israel President of the Supreme Court. Then there are 4 politicians, 2 ministers, including the Minister of Law, and 2 members of the parliament, usually 1 from the opposition, 1 from the coalition. In the last 10 years, both of them are actually from the coalition, and 2 members of the bar. So usually until 2008, it has been a committee with 4 politicians and 5 jurists. Notwithstanding, until the early 90s, one could not become a Supreme Court justice without the consent of the Chief Justice. After 2008, the system has been altered, and now in order to elect a Supreme Court justice, you need a majority of 7 members out of 9. And now, following that kind of a legal amendment in 2008, there is actually now a good balance between politicians and Supreme Court justice and the bar. However, in the last few months, and the new coalition would like to radically change that system and changing it in a way which is politicizing the judicial process. Now, there are 3 reforms which have been submitted by the designated coalition. One reform, which has already been presented on paper, is to reduce the number of justices to 1 out of 3, only 1, and to elect 6 politicians to the committee, which means that the whole process of judicial election would be completely politicized in a very polarized country, and it would be politicized in a way that only conservative justices would be elected to the Supreme Court. The other reform which has been offered is to reduce the age of retirement to 65, which means that 4 liberal justices would have to retire immediately. And the other reform, which has been suggested, is to pack the court in a way which is somewhat similar to the United States in the 1930s, in the 1937 proposed bill in the United States, namely to nominate 18 justices to the Supreme Court, which again would actually eliminate any liberal portion of the justices in the Supreme Court. Last and not least, and it might be an issue for a different seminar, why there is such an urge to politicize the judiciary with an emphasis on the Supreme Court. One, the ultra-Orthodox parties, the Haredi political parties, would like to block the process of privatization of religiosity, which has been very prominent in the Supreme Court rulings between the mid-80s till nowadays. Secondly, they would like to block the gender equality. And thirdly, like in many other countries, we have populist urge to block a progressive court, or what seems to be a progressive court, because as Professor Kedar will explain, it has certainly not been progressive regarding the Palestinian-occupied 1967 territories. Thanks very much.
Thank you very much, Gadi. And now we'll hear about other reforms to the public legal service and about the rhetoric of the democratic rhetoric underlying very undemocratic reforms. And we have the pleasure to have Dr. Maya Mark with us. Maya was a postdoc at the Minerva Center, and currently she is a lecturer at the Institute of Israel Studies of Ben-Gurion University. Maya, please.
Thank you, Eli, and the Minerva Center for organizing this important event. I will speak about the use of allegedly democratic arguments to defend distinctly anti-democratic moves. So the arguments offered by the supporters of the reforms are presented as democratic, straightforward, and fact-driven arguments. However, a deeper review of these claims clearly indicates that they are based on a distortion of basic terms and more than a few inaccuracies. The first argument attempting to justify the weakening of judicial review in Israel is the ambition to maintain the separation of powers. Although this principle was first formulated centuries ago, it remains valid till this day. Its underlying rationale is that power can be abused and therefore it should be divided. In modern legal thought, this idea is the bedrock on which judicial review is justified. That is, not only does the principle of separation of powers do not contradict the annulment of laws by an independent judiciary, but judicial review is the very manifestation of it. The composition and essence of the concept of separation of powers, is therefore completely different from that present by the proponents of the reforms. This is a clear case of using democratic rhetoric to justify a move that is distinctly anti-democratic. Another member of the distortion of terms club is the governance. The basic argument here is that judicial review, legal advisors, and other gatekeepers undermines proper governance. In order for the government to govern, structural barriers limiting its power must be removed. Using the metaphor made by former Justice Minister Ayelet Shaked, the government is Gulliver, who has to break through the ropes that bind him and limit him from breaking forward in full force. This is a complete misrepresentation of the core essence of the principle of governance and of the acceptable worldwide indices used to evaluate its quality, such as the World Bank Index and the OECD Governance Index. The concept of governance does not mean the entrusting of unlimited power to the executive branch. Rather, it draws primarily from basic democratic values and principles. The argument stating, let the government govern, is based on a seemingly democratic logic. Increasing governance is the realization of the majority rule. Only that the suggested model of governance does not implement the rule of the majority, but quite the opposite. Among other things, mechanisms of checks and balances are designed to prevent organized groups from gaining unproportionate power and achieving their goals at the cost of the general good. It is not a coincidence that the most enthusiastic supporters of the reforms represent minorities which manage to effectively advance their interests and strive to succeed further. Like the argument for the separation of powers, the lack of governance argument is both a conceptual disruption and a cynical use of democratic terminology in order to promote measures that are in essence anti-democratic. However, when it comes to public discourse, this is a highly effective claim, since it allows the government to shirk responsibility for failures. Whenever a public conflict or crisis arises, a utopian vision can be fobbed off to the public. If only we had governance, all of Israel's problems would have long been solved. If only obstacles such as legal advisors, public servants, gatekeepers, and first and foremost, the Supreme Court, could be removed from the path, all our problems would be gone. This move is successful, especially when it involves issues such as the Jewish identity of the state, security threats, and dealing with terrorism and immigration. A public narrative that portrayed the legal system, as opposed to the government, as responsible for the policy in these issues, directs feelings of fear, frustration, and despair towards the judicial system, making it in practice into the enemy of the people. A third and key argument in a justification of the reforms is the comparative argument, claiming that Israel should resemble other countries, a country in which the court has no authority to overrule laws, another country in which the attorney general position is designed differently, and a third country where judges are appointed by politicians. These claims are essentially manipulative, since the comparison is not made between systems of checks and balances, but rather between fragments of different systems of government. A comparative study conducted by the IDI shows that Israel is the only democracy in which the only restraint on power of the executive branch is the Supreme Court. This is a unique phenomenon that is unparalleled in any democracy in the world. In all the countries to which Israel is compared, there are several institutional and structural mechanisms that maintain checks and balances. Some examples are the existence of two houses of parliament that monitor each other and the government, a committee whose task is to ensure that legislative measures do not violate human rights, commitment to the ruling of the European Court of Human Rights, separate elections to governmental institutions, the distribution of power within the legislative branch, etc. In Israel, none of these mechanisms exist. Comparative arguments are therefore invalid arguments, which knowingly ignores the core question: are the joint elements of a given system maintain checks and balances, and how? However, from a PR perspective, the comparative argument is in many ways a winning argument, not because it is correct, but because of its many advantages in terms of marketing. The Israeli public, like any public, is not familiar with the ins and outs of its legal system, and is certainly not familiar with the mechanisms of other legal systems. Effective political propaganda can present incomplete and distorted information about the structure of other countries' governments, without the public having the tools to judge the quality and reliability of this information. Sorry. In this war of narratives, there is an advantage for those who use short and simple messages over those who use long and complicated ones. It is much easier to argue that in a particular country, the court is not authorized to overturn laws than to explain that this may indeed be the case, but there are no less than 3 other mechanisms that limit the power of the executive branch in that country. Very few people are interested or able to listen to a complex legal lecture, even if every word in it is true. Another advantage of the comparative argument lies in the fact that comparison has a relaxing effect on the public. It is easy to convince the public that there is nothing to fear if the suggested reforms are meant to turn Israel into Britain or Canada, stable democracies by all accounts. Similar to the maneuver that renders the concept of separation of powers meaningless and distorts the concept of governance, the comparative argument also employs supposedly democratic examples and concepts to justify that which is distinctly anti-democratic. Thank you.
Thank you, Maya. Your camera escaped, so you couldn't see.
So you heard me, but you didn't see me.
Right. So thank you for your contribution. And our last speaker will relate to the changes in the command structure of the army and the police and what does it mean for the territories, is Professor Sandy Kedar, an expert in property law and land law, law and geography, member of the faculty of the University of Haifa, the Faculty of Law. Sandy, the floor is yours.
Okay, thank you. I would just say that I'm doing a research in the recent years on the land regime in the occupied territories, and I'm mainly an expert in the land regime, but also more than international law, but I'm sitting here also for Professor Itamar Mann, but I have a basic knowledge of the relevant international law. So I will say just a few short things. First of all, the situation of the occupation of the West Bank by Israel, or the occupied Palestinian territories, is based, even according to official Israeli approaches, on the international law. And the temporary sovereign in the international law is the military commander of the West Bank. And he actually is the source of legislation that supersedes or is limited also by the international law. So essentially, the law in force is the law as Israel discovered it when it occupied the occupied territories in 1967, And in addition, the military commander can legislate, but subject to severe limitations that are based on international law. So, and of course, there is a lot of difference between the position of the official position of Israel and the major views by international legal scholars and institutions. For example, Israel does not accept the view that the settlements are illegal. Most international law and scholars, institutions, and so on believe that it is illegal, and so on. But so far, Israel at least maintained a facade that it did not annex the occupied territories, and it remains as something that to be solved in the future. In fact, it was a lot of a facade, but I think that sometimes changes, incremental changes, can transform quantity into quality. So I'll start very shortly with the two initiatives that are not yet. I mean, I didn't have time to follow today the news. I was sitting until recently. But at least the idea is to transfer to Itamar Ben-Gvir, who has been a follower of the Kahana organization, which was declared also a terrorist organization. The Kahana organization was declared as a terrorist organization, as far as I know, by the United States. He's going to be the person in charge of the police, and he will also get under his direct command the border control that is now in the occupied territories. Now, those you have even the facade of having the military commander controlling the area. You have a direct control by a minister whose ideology is clearly racist and anti-Palestinian and so on. So that's one example. The other is the civil administration. So according to the system that was in charge, essentially the person who controls the situation in the occupied territory, as I said, is the general in charge of the West Bank. And under this person was also a body that is called the the civil administration, who supposedly managed the life of all people that are in the occupied territories, both Palestinians and Israelis. In fact, actually, many of the Israelis living in the occupied territories enjoy direct access to Israeli courts, to Israeli administration, but at least formally it was a rule, the power emanated from the military commander. Now, this is going to be transferred directly to Minister Smotrich, also one of the most extreme right persons. And Smotrich will receive the power to nominate the commander of the civil administration. Again, we're rising, or the disguise is not only we end the kind of the party of the disguise party, because it will be clear that the person who controls the civil administration will be the minister, and the minister already said that one of the things in our agreements apparently about it, that will legalize all the illegal outposts. And when I'm talking about illegal outposts, it's settlements that are not even recognized as legal by the Israeli legal system. I'm not talking, I think that by international, all settlements are legal, but according to Israel, there are settlements that are built on private Palestinian land or without authorization, and therefore they are illegal. So this is the person who will be, these two persons will be effectively the sovereign, or by power of the government, but the direct control over the occupied territories. Now, when we look at the attempts to change the power of the Israeli Supreme Court, so the Israeli Supreme Court, serving as a high court of justice, served as a unique position in which Palestinians could petition directly to the highest court of the land. Now, it was a decision which is debatable, but essentially some can see it as a part of judicial annexation of the occupied territories, but in essence, the fact that Palestinians who don't vote could reach the Supreme Court served as a way to mitigate some of the inherent disadvantage. And the Supreme Court, as Eli said, and Gadi before that, has been very minimal and extremely non-activist in its position. I just gave a lecture a few days ago in which I maintained that actually the Supreme Court has been a washing machine for the occupation in the sense of legalizing many things that it should not have legalized in the occupied territories. However, it had some power over the government and even more over the parliament. So, for example, when the Israeli parliament legislated something that is called the Arrangement Law, which was planned to legalize illegal taking of private Palestinian land and transfer it without any payment by the settlers to settlers, the Israeli Supreme Court did strike down this law. So it's at least kind of facade or some attempts to show, for example, that the Israeli parliament could not legislate in the occupied territories. Now, the minute we take this power from the Supreme Court, the power to strike down legislation, and also the other processes that were detailed by the previous speakers, the Supreme Court will not be able to interfere at all in what's going on in the occupied territories. And then, in fact, what I think is we'll see the reality. And the reality in the occupied territories is you have one territory and two systems of law, one for Israelis and one for Palestinians. And it has been disguised for, at least you say, okay, it was mitigated by Supreme Court. It will not be mitigated by Supreme Court. So we'll have one group, the Israelis, that are settlers, that it's, by most international law scholars, it's illegal. The settlers are illegal there. It's illegal settlements that can vote to the Israeli parliament, that many of them are in the government, like Smotrich and Ben Gvir and others are living in the occupied territories. We also have Supreme Court judges that are in the occupied territories. So you have one group that has almost full rights, and another that are like residents without any kind of legal rights. And when you have one territory and two systems, it becomes more and more similar to the crime of apartheid by international law. So I think that in a way, I am, if we want to conclude in an optimistic note, I'm optimistic in the sense that I think that foreign countries cannot, I mean, when Russia, for example, is under international sanctions, and Russia gave citizenship to Ukrainians who were under in Crimea, for example, Ukrainian received Russian citizenship, even in Russia. So I think it will be even more difficult for the European, for the United States to ignore the situation on the ground, and maybe we'll get some more interference in what's getting even much worse than the situation in Hungary and Poland, because we have here a situation. I don't think it's a democracy. I mean, I disagree. I'm not part of the Minerva Center, so I don't represent them. I don't think we are in a democracy anymore. I think we are much more nearer to an apartheid, and the party might be over, at least the disguise of party. Thank you.
Thank you very much, Sandy. We will move in a second to a questions and answers and comments session, which will be moderated by Professor Deborah Shmueli, the fourth angle or principal investigator at the Minerva Center. I just want to summarize our concerns. As was mentioned for the four speakers, the initiative of the current government is basically to abolish all checks and balances on the power of the raw majority, from the power of the judiciary through the independence of the police service. One thing that we didn't discuss is the law that is being now voted in the Knesset, that it will allow Itamar Ben-Gvir as the minister to basically dictate policies, including, for example, priorities of opening files and investigations. This means politicizing the police. The army, as Sandy said, and what we really didn't elaborate on is the whole Attorney General apparatus. Attorney General in Israel is also a very important balancing power to the political branches. The Attorney General is the head of the public prosecution. He is the advisor of the government, and he is in charge of all the legal advisors of the ministries. As I said in the beginning, one of the initiatives is to change this, to split the Attorney General position to a Director of Public Prosecution and advisor to the government, and basically give independence to the ministers to appoint their legal advisors. And as a check and balance mechanism, this will disappear and will allow ministers to do a lot of things, corrupted things, without the possibility of the courts, because of lack of judicial review and the changes in the judiciary, to control their administrative acts. So this has to be taken on board as well. And as I said in the beginning, we are not attempting to be comprehensive in all the reforms that are being put forward. We don't think that these are just threats, because these reforms are already anchored in the coalition agreement, and therefore we are very worried. Deborah, the floor is yours, and those who are interested to ask questions or make any comments are please either in the chat or by raising hand acknowledge yourself.
Absolutely. Eli, Amnon, Gadi, Maya, Sandy, thanks very much for the sobering analysis and insight. Out of grave concern, I see that we have new ideas about optimism. I'm not quite sure I'd call it optimism, but I see that Katerina would like to ask a question. Again, just let me know in the chat or by raising hand, and I'll call on you, Katerina.
Yeah, thank you. Thank you for this wonderful panel, and also for, like as Eli said, not a fully complete picture, but I think a very distinct picture. My question, or maybe this is something we can discuss, or that would also be a little bit more of a comment, is now we looked a little bit in the occupied territories, but if we follow up also what happened inside Israel, like I'm thinking of the events of last May in 2021, we just had a court sessions where people like from Akka got condemned to 10 years in prison, whereas settlers from Lod who killed Palestinians are outside of prison. So would you, like also with your background in like legal studies, maybe also see that this shifting of the legal system happened also before, like that simply like there was kind of a door opener saying, for example, someone like Ayelet Shaked, Naftali Bennett, who already shaped the way. So, and is there a mechanism at this point to reverse it? Like I'm really trying to think, like, is it coming out of the blue? And I have the feeling it's not. So it is something that has already been long on the way and that had been prepared for. And do you see any mechanisms that it is reversible, or that the legal system has become already so scattered and that things are already able to set that haven't been maybe able to be set before, so that we are really on a way to a very different future?
Gadi first.
So I will start and then.
Thanks.
Thanks, Katrina, very much for a very good comment. So as we have described, we are in a watershed elections as far as attack on the legal system. And I do agree that also in the past, I mean, only the previous government, which we call the government of change, has continued to settle the territories. To the best of my memory, they've established 10,000 units of housing in the occupied territories, which is about 50,000 human beings. So on the one hand, I don't think that only the elections have changed dramatically as far as we are talking about the 1967 occupied territories. The changes may be looming regarding domestic other issues like female equality, religion and state. One last sentence. I don't belong to the apolitical and camp. I'm not in despair. I think that Israel does have a civil society, and quite a strong one. And Israelis have demonstrated it in the past. We do have a strong legal opposition to what is going on. And history shows us that historical processes are dialectical. And Israel still does have an arsenal of options to resolve the Israeli-Palestinian conflict. So on the one hand, I'm very critical of what is going on, as I've explained regarding the judiciary, but to say that this is the end of Israel and those kind of, I don't see an empirical basis for it. And I belong to a much more optimistic end.
Okay. Shall I take it?
Yeah. Sure, Sandy.
Yeah. So thank you, Katrina. I agree. I think that these things did not start yesterday. And in general, we can talk even about the problematics of attempts to be Jewish and democratic, to the essence. And the nationality law and the systemic, there is a systemic discrimination of Arabs in Israel, or Palestinian Arabs in Israel proper. And I think that Shaked did an amazing job from her point of view of packing the court with judges that are more. I'm not sure I don't like the word conservative. I don't think that these judges are conservative. They are right wing. They are nationalistic. I don't think they are conservative. They are making a lot of things that are not conservative, according to my view. And I think I just spoke today with some people in the judiciary, and they're feeling the chilling effect also. If you're we talk about the Supreme Court, but I think a lot of the interesting and important stuff is going on the level of what happened when a Jew throw stones and Arabs throw stones, and this is the level of the lower courts. And the lower courts, the word judges, as everybody else, want to be promoted, and they know where the power is. So even if they are not even if their ideology is not a right-wing ideology, they know what they have to do. And not everybody is very courageous. You know, it's there are some people that are courageous, and they pay a price. So I think that in a way we see what I think we see here is an accumulation of things, and therefore when the government is saying what happened, already some things happened before, it's true, but there is something where the quantity is so big and it's so fast that we can see also this kind of, not only the formal processes, but the way soldiers feel in the West Bank now vis-a-vis, not only vis-a-vis Palestinians, but vis-a-vis Jews on the left. The amount of all the informal messages. I must say, I think that the Israeli society is much weaker than Gadi thinks. I don't see, horrible things are happening right now, and they will pass, and they will happen, and a lot of people will adjust. It happens everywhere. People adjust, and Israelis, especially the youth. It's a very deep. When we talk about Israeli society, the youth is not rebelling. I've been demonstrating for a long time, and the average age of people that are demonstrating about things is way too high. So I don't see the internal forces that will stop, not the judges, and I think that they will. I assume that soon the Attorney General will have to resign or will be fired, and nothing will happen. That's my prediction. Nothing will happen. Well, maybe we'll sign another paper, but nothing really will happen. Yes, I'm talking. Yeah, okay.
Okay, Eli?
Just to be very simple and quick, you ask whether the new government is trying to destroy a healthy and ideal democracy. No, Israel is not a healthy and ideal democracy. But to be scientific or academic, there is a world, there are academic rankings of democratic quality, various, VDEM, The Economist, others. And Israel is currently ranked in a quite dignified, flawed democracy in some indexes in the 30th place, in some index in the 40th place in the world. I think that materialization of the reforms that the government is suggesting, is putting forward, is implementing, will deteriorate our ranking lower than Poland and Hungary, which are now ranked as flawed democracies, as hybrid regimes. So from a scientific academic perspective, this is a major change, although some slower change is certainly observable in the last 2 decades. Yeah.
Okay. I just want to read a question from Keith Gordon, but Keith writes, as a diaspora Jew who marvels at the good things that occur in the state of Israel, the proposals of the incoming government have shaken my faith. My question in short, is there still hope? The longer question, what can I point to in order to persuade myself that Israel is still a liberal place? 2, can a future government be relied upon to reinstate the checks and balances? Toda. Maybe Amnon? God.
Yes, I think I can jump in. So one example is this: what we're having right now. We're having this, and I'm actually surprised. Unlike Sandy, it depends on what you focus, but I'm actually surprised at the resilience and vibrancy of Israeli civil society up till now. The reaction of the Israeli Legal Academy, the reaction of the high-tech segments, the reaction of other initiatives.
The bar.
The Israeli bar, has shown that at least there's a sense that what is happening is not only unwanted, but is a cause for alarm and cause for action. And we've been participating in discussions. We're invited to go to small groups of people who care about this. So we go to people's homes and we discuss those initiatives. And, demonstrations is one thing. There could be strikes down the road. I think that if the government touches the judiciary, if the government touches the issue of judicial appointments, my sense is there will be a harsh reaction by even by the business sector, who relies on the neutrality of the bench for pure business reasons. So I'm not overly optimistic that we will be able to just by our sheer will and standing on in demonstrations be able to just annul or somehow hinder the ability of the current coalition to legislate. However, I do think that, look, at the end of the day, it's only 8,000 people that divide the current government from those who oppose the current government. If you look at the number of votes, now, of course, this is misleading because you have a threshold for being elected to government, etc. And anybody in the United States knows that there's a difference between popular vote and the vote as represented in elected institutions, including the United States presidency. So, but we cannot ignore also the notion that it's only 8,000 votes. I do think that come the next election, again, if we persevere, if we keep, it's going to be a long haul. It's not just a 6 days battle where, things can be solved one way or the other. It's going to be it will take some doing, but we're not going to go down without a fight, I don't think. And I think that, we believe in the liberal values of the state of Israel. To those who believe in the liberal values of the state of Israel, some do not, but those who believe in the liberal values of the state of Israel still have some hope that these can be reinstated, at least to a degree. And then comes the next election, the next government, but for judicial election. But for the judicial election, all other suggested reforms are reversible. If not to full extent, at least 90 or 95% are reversible. Once you touch the judiciary, you appoint judges, and then you tilt the internal machinery of the judiciary. That's very difficult to undo. This is why the reaction, I think, will be harsher there. But I'm willing to raise a white flag and say, that's it. Hungary and Poland, please welcome us to your club. Yet, I'm not saying we won't get there, but there's still room for some hope.
Sandy, thanks, Amnon.
Yes. So again, I want to. I'm sorry, but I'm very pessimistic. I think when we look, for example, at the elections, theoretically, the Arab parties, at least part of the Arab parties, could have been ousted from running from to the parliament even before by present statutes. And the body that allowed the Arab parties to run for election was the Israeli Supreme Court. And I think that you don't even have to change the structure. It's enough to retire the judges, the more liberal judges, and in the next elections, the Arabs will not vote. It's 20% of the popular vote, and we will not be able to gain again the government. That's one thing. So things are not the same. I think that when Itamar Ben-Gvir will nominate the police force, and he already asked for 5,000 new policemen, and will get the policemen from the settlers. This will be a completely different regime. There will not be demonstrations. And I think that, and I also must really working, Eli, working on a paradigm of international parameters of Israel as democracy, it's without counting the West Bank. And this is false, because there is no green line in any effective way. So yes, within the green line, we're better maybe than Hungary and Poland. But if you see who wins the elections, the 500,000 settlers that are in the occupied territories, we are not a democracy, not a flawed democracy, not a hybrid system. And I think that to go into, it's kind of going to kind of formalistic. The occupation has been here since 1967. It's not going anywhere. If it will be end, then we can talk about Israeli democracy. But as long as you have an apartheid system in the occupied territories, I think that as academics, it's not serious to talk about Israeli democracy. Even if some kind of outside bodies that don't understand are only counting what's going on within Israel in the green line, where you don't look at who are the judges, who are the people enforcing the government, who are the members of the parliament, who is winning the popular vote. It's all from the occupier. One group is voting, another one is not voting. And for me, I think that doesn't stand in the threshold of a democracy.
Okay, thanks, Sandy. Maya, who we can now see.
Thank you. I actually agree with Amnon. And I think that extreme conditions sometimes lead to extreme actions. And I think it's worthwhile looking at just one example from the last few weeks. The nomination of Avi Maoz, a nationalist, extreme right, religious politician of some sort, to a position that I would have assumed that there are maybe 10 people in the entire country that realize the significance of this position. Like this, you need to really to have a profound understanding of the structure and authorities within the Ministry of Education, and you'd think that this would be something that 10 people would understand. And yet this declaration of the intention to nominate this person created a countrywide protest involving people from local authorities that some of them I know, and I can't remember hearing them ever saying anything political, and a very fierce protest, public protest that was completely unexpected. And I think these examples, and I'm not an optimistic when it comes to Israeli politics. No one can suspect me of being an optimist. But I generally think that it's very difficult to predict what is going to happen. And another very short point, the public discourse don't emphasize enough the economic outcomes of these initiatives. And there are severe economic outcomes. And once they become more apparent, I suspect that organized groups, I think we're starting to see it with the bar, that I think everyone here were very surprised from the very ideological standpoint that they expressed. But we will also see it from the high tech and from investors. And I think Israel is already getting signals from the World Bank, and we're talking the country credit ranking. I hope I'm using the right term.
Yes.
There are severe economic outcomes. And I think we can be carefully optimistic about the Israeli public's willingness to fight for the very basic freedoms and economic interests.
So we were asked whether Israel is a liberal democracy, and I should say Israel has never been a liberal democracy. I've published an article in Terry Holiday and Malcolm Philly book about the legal profession. So if you take the basic criteria for being a liberal democracy, Israel was not established as a liberal democracy. Most democracies are not liberal. Notwithstanding, Israel did have a package of liberal liberties, and as of yet, it does have some package of liberties. You know, I could have asked somebody, do you think that the United States under Trump has been a liberal democracy, or will it be a liberal democracy? Is the United States, after Jackson versus Deb, the court ruling about prohibition of abortion, is a liberal democracy? So I think that on the one hand, we are talking about a process which is endangering the very essence of Israel as a democracy, not only as a liberal democracy, which it has never been.
Okay, Gadi, thanks. Sylvia.
From the point of view of economics of transition, I listened carefully to the discussion with great pleasure and honor. It seems to me that the focus is on static factors. There is a symbiosis going on, and this symbiosis is very nicely analyzed in the book by Professor Jacob Metzer, The Divided Economy of Mandatory Palestine. Now, this is true that there is a multiplicity of systems in place in the locations beyond the Green Line, but there is also something which is much stronger than the appointment of one or other minister, one or other party. There is a symbiotic process. I therefore dare to express some optimism that the symbiosis among the peoples that actually inhabit this area paradoxically can bring about a liberalization and a mutual tolerance that is anchored in mutual interests. First of all, I carefully paid the attention to Professor Alexander Kedar calling High Court of Justice that this is an address of appeal of land issues by the Palestinians as some kind of a concealed occupation. But I think that this concept, occupation, is quite, let me say, I would say, due to de facto economic integration ongoing, it is a concept which is neither de jure nor de facto updated. So the issue is that there wasn't legally a Palestinian state that could protect the property rights of Palestinians on Jordanian territory vis-a-vis the Jordanian government. No one called the Jordanian rule of the Palestinian population of those areas an occupation. So the question is, that is, there is an integration going on perforce, whether the Palestinians inhabiting those territories win or lose to be ruled by the Jordanian government or by the Israeli government, and which, let me say, influence they may have upon the transitions in this rule that accommodate their interests better. This is a human rights issue that is anchored in individual property rights in land. Now, and economic rights, political rights that are outgrowth of the negotiated with the economic assets.
Good point. Sandy, do you want a short answer?
I just, maybe the situation of the Palestinians under the Jordanian courts would not have been better than in Israel, but the question is, it's not the question. The question is whether they are discriminated, and are surely heavily discriminated. The Supreme Court, according to my view, is one of the major bodies that allow the taking of land from Palestinians and moving it to settlers. And I've been doing in-depth research in the last 4 years on this issue. So I don't know. I mean,
even longer.
Even longer. And I mean, I think what we have to talk here, my position is that as academic, we have to speak according to knowledge and not about wishful views. So I frankly don't understand, I mean, the fact that Jews are penetrating into the occupied territories, taking away land from Palestinians is clear cut. It's nobody even questioned this. Second thing is, I really want to ask my colleagues, can you offer some definition of democracy? Because you're using this word democracy so easily. And I think the basic thing of democracy is to have you cannot legislate without having elections. It's not a democracy. And the Israeli parliament does legislate on the occupied territories. Even and there are laws about taxes and so on. So I think that this facade of maintaining this facade of green line, when we all know that the green line has been erased, except in the only place where you find the green line, and is when we talk about Israeli democracy. And I think that I mean, I really ask you to really reconsider your position, dear members of the Minerva Center, of whether this is a correct paradigm to analyze Israel. And I think that I challenge you to really talk about, question what is a democracy, not only on formalistic views, because we're also people that are working within a law and society view, and not only on formal legislation that has no grounding. So I'm just thinking that we should reconsider. I mean, I have to reconsider. I don't think that you can analyze the Israeli regime, not the Israeli state, the Israeli regime as a democracy. It was not that before, but certainly not after the current government or the upcoming government.
Sandy, thanks. Eli, would you like to sum up?
Yes, thank you very much, Deborah. I will say a very simple thing, it's reconstruction, Deborah knows it very well, is always much more difficult and much more timely than destruction. So reconstruction of what is apparently going to be conducted here in the next year will take years, if not decades, to reconstruct. We beg to differ on the definition of current Israel, but I think that all of us, the speakers, are unanimous that the changes proposed from this coming government is not a slippery slope, but a revolution. Whether Israel is currently a democracy or not, the changes that are proposed will bring whatever we have here to a much worse situation from a democratic perspective. We very much thank you for joining us. We conducted this session in English because I think it's very important to convey And this was the main purpose of this session, to convey you information about the proposed reforms, because some of them are actually taking place now or will be materialized very quickly. And especially in the light of the fact that the future Prime Minister of Israel, designated Prime Minister Benjamin Netanyahu, talks in a very different voice and tone when he talks to foreigners or in English. So our aim was to alert you, media, diplomatic circles, academics around the world, that we are in extreme condition. And it will be great if you can forward our message and, if possible, voice concerns about the future of Israel. Thank you very much for joining us.
Thank you all.